In this video, I'll explain how to obtain power of attorney in Indiana. I'll cover the different types of power of attorney, the essential requirements, and the benefits of using statutory forms. So by the end of this video, you'll be able to confidently create your own Indiana power of attorney. And by the way, if you would like to get help creating power of attorney, I recommend you contact people from lawdepot.com. They're professionals and they will be able to help you. I'm going to leave a link to their website down in the description of this video. And with that in mind, let's jump right into it. Understanding power of attorney. What is a power of attorney? A power of attorney is a legal document that grants specific powers to a trusted individual, referred to as an agent or attorney in fact, to handle certain matters on your behalf. These matters may include depositing checks, filing taxes, or even managing real estate transactions. Types of power attorneys in Indiana. Indiana recognizes various types of power of attorneys, but two commonly used ones are financial power of attorney. This type allows someone to manage your financial and business affairs. It's especially useful for estate planning. And second one is called medical power of attorney. In Indiana, this is referred to as a power of attorney for healthcare and appointment of healthcare representative. It permits someone to make medical decisions on your behalf. Both these power of attorneys are typically durable, meaning they remain effective even if you become incapacitated, making them essential for unforeseen situations. Legal requirements for a financial power of attorney in Indiana. To create a valid financial power of attorney in Indiana, you must adhere to specific legal requirements. Mental capacity. The person creating the power of attorney must be of sound mind. The exact definition of mental capacity can vary, so consulting a lawyer if you're uncertain is advisable. Notarization or witnessing. Indiana law offers two options for signing a power of attorney. You can either sign it in the presence of a notary public or in front of two witnesses. Opting for notarization is often recommended as financial institutions are familiar with notarized power of attorneys. If your agent needs to handle real estate transactions, notarization may also be required for your country's land records. The witnesses should not be an agent or successor agent in the POA, someone granted other powers or benefits in the power of attorney, a spouse or descendant of the agent or person granted other powers. Steps to obtain a financial power of attorney in Indiana. Here's a simple guide to creating a durable financial power of attorney that's valid in Indiana. Step number 1. Choose a method. You can use some DIY forms provided by some private company. Consider a user-friendly option like lawdepot.com, which guides you through creating a valid state-specific POA. Alternatively, consult an Indiana lawyer to create a POA, especially if you're including as part of a comprehensive estate plan. Step number 2. Define agent's powers. Decide on the powers you want to grant your agents. This might include real estate transactions, banking, financial matters, retirement plans, and more. Your power of attorney is durable by default unless it explicitly states otherwise. Step 3. Notarization. Sign the power of attorney in the presence of a notary public to ensure its validity. Notarization is often preferred, especially for real estate transactions. Step 4. Secure the original. Store the original power of attorney in a secure yet accessible location known to your loved ones. It should be readily available if your agent needs to act on your behalf due to your incapacitation. Step 5. Share a copy. Provide a copy of the power of attorney to your appointed agents so they are aware of its contents. Step 6. File with the recorder's office. If your agent requires the authority to conduct real estate transactions, file a copy of your power of attorney in the land records office, in the relevant county or counties where you own real estate. Step 7. Share with financial institutions. Consider sharing copies with banks and financial institutions your agent might need to deal with in the future. This can streamline the process. Naming an agent or attorney in fact in Indiana. Legally, you can choose any competent adult as your agent. However, practical factors like trustworthiness and location should influence your decision. While Indiana permits co-agents, it's often advisable to have a single agent to minimize potential conflicts. Appointing a successor agent as a backup is a wise move in case your primary agent is unavailable. When does my durable financial power of attorney take effect? By default, your financial power of attorney in Indiana takes effect immediately unless you specify otherwise. While you can create conditions that must be met for it to activate, this springing power of attorney is not commonly recommended due to potential complexities. When does my financial power of attorney end? Several scenarios can lead to the termination of your financial power of attorney. Revocation. You can revoke the POA at any time as long as you're mentally competent. No available agents. If there is no agent or successor agent available to act on your behalf. Court invalidation. In rare cases, a court might invalidate the power of attorney if it determines that you lacked mental capacity when signing it, or if you were a victim of fraud or undue influence. And don't forget that if you would like to get help creating your power of attorney, I recommend you contact people from lawdepot.com. They are professionals and they will be able to help you. And I'm going to leave a link to their website down in the description of this video. I hope this video was helpful. Thank you so much for watching. Subscribe.